But this also kind of points to a larger issue that's hitting the streaming platforms now, which is Wall Street now wants them to make money. They've sort of hit their peak with audience growth. So now they need to start pinching dollars here and there. And so you have this fight between Paramount and Warner Brothers. But also, as the Hollywood Reporter was mentioning recently, a lot of platforms are starting to pull old content, like old shows, old movies from their
Yeah.
streamers, because they don't want to have to pay the royalties anymore and save money
Yeah.
that way to talent, to production companies that way.
Not Billable is brought to you by Lawtrades, the largest marketplace for hiring freelance corporate legal talent. With over 3,000 vetted attorneys, legal operations professionals, paralegals, and contract managers, an app to make tracking and paying for work easy, and world-class 24/7 customer support, Lawtrades is the best place to hire full-time or flexible legal talent at a fraction of the price of traditional outside counsel and staffing agencies. Get matched to great candidates today by using the link in the description and mention this podcast to get your first 10 hours of legal work for free.
Hey everybody, I'm Oren Peleg, back with Legal News Update, joined as always by fellow law trader extraordinaire, Matt Margolis. Matt, how you doing, man?
You're so kind.
Of course.
It's like you're just like a legal hype man. That's what you.
That's my role here. Yeah.
Well,
Cool.
You do a really good job.
Yeah, well, thanks. So do you. So, well, let's dive in then for this week. What are we talking about this week? We're talking about the streaming wars, which have arrived in South Park. That is not something I ever expected to say. California is starting to stand up to AI, looking to regulate some of the industry. And AI-generated art is now raising some copyright issues, some copyright questions, something we've talked about before, but this is a new case that's pretty interesting. Some of the smaller stories we'll take a look at. Pandemic-era lawyers, are they undertrained? And we're going to see how the Texas two-step is continuing to unravel. So that's another big thing. But let's jump in with the South Park story. So back in 2019, HBO Max, which is now owned by Warner Brothers Discovery, signed a contract with Paramount for $500 million, saying that they would get exclusive rights to streaming South Park on HBO Max. Well, Paramount at the time asked if they could share streaming rights. HBO Max said, absolutely not, this is ours. And so it seems, as HBO Max, or I guess Warner Brothers Discovery, is now accusing Paramount, that they sort of use some verbal trickery in the contract to start calling episodes specials or movies or this and that, anything but an episode, so that they could withhold a lot of the content. So now they're embroiled in a lawsuit, and this is a major thing for streamers.
The funniest part about this is I'm pretty sure there's a South Park, again, classified maybe as like a series or a movie or whatever they classify it as, I think on the streaming wars. And there's this whole joke, and they use this analogy, a giant metaphor of a river, a stream, and everyone writes to use the stream. And it's really funny that this lawsuit is coming to be, given the fact that they've already, it's almost like the joke, like Simpsons have already done it, and South Park has already done it.
Yeah.
And it's definitely an interesting one because I watched South Park, and there were these exclusive 3-part, I guess I can't call them an episode because there's legal implications to that, episode movies, what have you, that were exclusive to Paramount. I would love to see the definition section, if there is one. I would assume so. It's a multi-million-dollar agreement, but I'd love to see the definition section to see what they define an episode as, what they define a movie, or what they define these other forms of the same South Park content.
Which, obviously will set whoever wins. It'll set a huge precedent moving forward. Now, what do you call a piece of content? Is it an episode? If you're licensing something, do you license everything in the canon of this, IP? Like, it'll definitely define things moving forward.
Oh, yeah. And I mean, it goes to a lesson, right? When you are drafting these definitions provisions, it needs to, I guess you need to contemplate whatever it could be called or whatever things could be considered.
Right.
Oh, it's not an episode. It's actually a movie. It's not a movie. It's actually a
special.
Clip. It's not a clip. It's actually a special.
Yeah.
Yeah, that's exactly a 3-part series.
Right.
3-part special.
Right.
So it's definitely an interesting one. I personally thought an episode was an episode, and maybe we're splitting hairs, but legally speaking, that's not the case. It's almost like the story of the comma changed the meaning of the contract.
Exactly.
Well, is it really an episode?
This is the Oxford comma of streaming, I guess. But this also kind of points to a larger issue that's hitting the streaming platforms now, which is Wall Street now wants them to make money. they've sort of hit their peak with audience growth. So now they need to start pinching dollars here and there. And so you have this fight between Paramount and Warner Brothers. But also, as the Hollywood Reporter was mentioning recently, a lot of platforms are starting to pull old content, like old shows, old movies from their streamers, because they don't want to have to pay the royalties anymore and save money that way to talent, to production companies that way.
Oh, absolutely. I saw it with HBO Max, where a number of older shows have been pulled that were fan favorites.
Mm-hmm.
I mean, that's the problem, right? If you're a fan favorite, I imagine that the royalty checks are larger and larger and larger. And I would also imagine that these fights over content are so important because everyone is taken to streaming. It's so fractionalized.
Yeah.
Our TV viewing experience,
yeah.
our content viewing experience. So any way you can to get a leg up on somebody, you're likely going to try. So, you could watch all of South Park on this one platform, but if you want to see the exclusive non-episodes, definitely not episodes, you should look over here. So I mean, that's it. We're in a content war. Who has the most content, the best original content, and why am I going to be watching on Paramount as opposed to Netflix, Hulu, what have you?
And eventually, you just know that eventually there's only going to be so many streamers and they're going to start collapsing in on each other, acquisitions, whatever. So to have these fights between HBO Max and Paramount, then what happens if they merge in 5 years? Then what happens?
Well, it's going to be a really funny antitrust. I don't know. We're in the era of like the antitrust. So like, But I mean, look, that was the implication, and you're nailing it, because think about the combo of Discovery Plus or Discovery and Warner Brothers, HBO Max, like that whole merger is exactly what you're talking about. Mm-hmm. And I fully expect, you're right, to see other smaller streaming services, channels, I don't even know what to call it anymore, combined with some of these larger giants.
Right.
And he's right. You're picking a fight with your parent company.
Yeah.
And you're like, all right, we'll settle this lawsuit, but you're actually under our umbrella now. We're actually merging.
That'll be really fun, from a distance to watch. But that sounds like that's what's coming.
Oh my gosh, it's gonna, whether we like it or not, antitrust. Outside of antitrust, if that's not the implication here, or it's gonna go back to like old school TV where we had like 5 channels.
Yeah, they're reinventing TV.
We did it, guys. We did it. Efficiency.
That's crazy. All right. Well, we have 2 AI stories today in our main section, but the first one of the 2 is California, which normally kind of sets or is faster than or more nimble than the federal government in setting up legislation, is now looking at Silicon Valley, is looking at things like ChatGPT and Google's Bard and all these things, and saying we need to start regulating this specifically in 2 areas. One, in how we use AI for hiring practices, if there's inherent biases, et cetera, we need to regulate that. And 2, in terms of privacy, right? Like, what am I feeding into the models? What is being shared otherwise, et cetera? So the California legislators are now starting to look at various bills to kind of get ahead of the game and start setting up regulation for this industry.
It's classic California. I mean, look, the CCPA is a good example. Like, we don't have a federal regulatory regime for privacy, and California took the charge for it. And fully expected the same thing for this, obviously, because this is where AI is being really fleshed out. Silicon Valley is obviously where you're seeing all of these AI, ChatGPT related startups. So no surprise there. If I remember correctly, President Biden put out a Bill of Rights, like an AI Bill of Rights, and I think this is more or less an extension of that Bill of Rights, or maybe actually setting more or less the real groundwork for it. I don't think there was any sort of enforcement mechanism within the Bill of Rights or the AI Bill of Rights. So I think that's probably what California is doing as well. And it's interesting, because I can understand it, the potential biases in hiring, right, using an AI tool to be like, hey, well, this is what I'm looking for, blah, 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 blah. And all of a sudden it spits out and says, this is the perfect candidate.
Right.
Or this may be the best candidate. And it could be facially neutral, but in practice, it acts with it discriminatory.
Right. It was written by somebody, right? Even if it's just the underlying code, you suddenly find out all the candidates that it's spitting out are white men. And it's like you weren't inherently looking for that, or you didn't put anything into your search query to get that. But yeah, that's the bias of the AI.
Yeah, absolutely. And then on the privacy side, oh, I can only imagine what people are feeding to,
Oh,
to
boy.
ChatGPT
Oh,
right
boy.
now.
Well, to that point, Snapchat just announced that it'll be integrating ChatGPT into its social media platform, calling it My AI, and it put out a pretty strong warning, which says, "Do not tell it your secrets. Do not rely on it too much for this, that, and the other thing." But they were very like, you're teenagers. A lot of you who are using this, please don't rely on this for for your secrets.
Tell me what to do if I get arrested for
Oh boy.
blah, 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 blah,
Oh,
blah,
boy.
blah, blah, in this location, in this. Also, this is my age and this is my actual name.
Exactly.
Um,
Exactly.
oh my gosh. I can only imagine. I don't even understand. Maybe I'm just getting old. Are we getting old? Where like I don't understand the merger of Snapchat with an AI tool. I just don't understand. Like, isn't it just like fun pictures you take really quickly? Maybe why am I removed from
The
this?
youth today, I don't know, man. I don't know.
They're using that AI to send funny pictures to each other. I don't know. I don't know what's going on here, but I could definitely see the concerns there. Where I mean, listen, I'm sure with Snapchat now you have people, right? You think they're instantly deleted pictures, I'm using Signal or something or whatever that app is that deletes your
Right.
text. No, they have all these pictures probably
On a
like
server somewhere, yeah.
it's
Well, but
maybe,
that's
listen, maybe they don't. Snapchat, tell me if I'm wrong there, but I mean, it's absurd. It's absurd. You have to put out this warning, like, don't give us your secrets with a tool.
But
like
that's a
this.
private company. One of the bills that's being introduced in the California state legislature is to say, public offices, like the state of California, the way that they use AI also needs to be regulated. Because if you have every social security number of everyone in the state of California being fed into an AI, you can see how that can become a problem, right?
Oh, absolutely. Any sort of personally identifying information. Also, I think there's also a disclosure element where you have to disclose if it is indeed like an AI and it's not an actual person, which is comforting. I would love to know if I'm talking to who I believe to be someone trying to help me, maybe an issue with some sort of like maybe with why water utilities. And I think I'm talking to a person, and all of a sudden I realize I've been talking to an AI tool the entire time. That is very helpful. That is a good component of the bill. I do appreciate it.
Yeah, which I know on Hard Fork, it's another podcast. They were talking about that recently, of how today we have, this email was sent from my iPhone.
Yes.
Maybe in the future, it's this email was sent by a large language model AI or something.
Please mind the perfect grammar.
If this sounds smarter than me, this was written by.
No, this wasn't written by my associate. This is indeed written by an AI tool.
That would be amazing.
That's awesome. All right, I'm going to say that for a tweet. If you're listening to this, I probably already tweeted this.
That's awesome. All right, well, let's take a look then at the second AI story, which is kind of interesting. We've talked in the past about how copyright and AI are kind of negotiating legally, where to land. And there's a new case. Well, it's a couple months old, but an artist by the name of Christina Kashtanova, sent in her comic book, which is called Zarya, I believe it's pronounced, Zarya of the Dawn, to the Copyright Office. She got it copywritten. Everything was golden. She got a letter a couple months later saying, actually, we didn't realize that the artwork in your comic book was generated by Midjourney, which is one of these AI platforms. And they revoked partial copyright on the artwork itself. So now she's suing, or she's, appealing this decision, saying, basically, I have to feed in a certain prompt, and that's the artwork here, right? The fact that it's almost like a paintbrush to a painter. This is just another tool now, so this should be copywritten.
Which makes sense, but in the same breath, that we talked about this in the past, that AI tool had to have been fed artwork from wherever, artwork that likely is copyrighted, that has its own copyright, to create this new derivative form of art. And it's just all these new IP considerations here where is this, can I copyright this because even though it was created utilizing other copyrighted works? You're right, is it just simply another tool that an artist can use to create an original art piece? all these questions.
Now, what's interesting is there's actually two legal precedents being cited here, or at least being referenced in this case, which are, they're kind of opposing ideas, but each is interesting. One was from 1997. It was a decision by the Ninth Circuit Court of Appeals in a case of Orantia Foundation versus Maahira. I'm probably butchering that name, but the basic premise was some organization claimed that a book was written by a celestial being and that they were copywriting what was written by this celestial being. And the Copyright Office says there has to be some human element. Some human has to have done something here. That's what copyright is for. So they overturned the copyright. So that's one. The other is back in 1965, a scientist at Bell Labs was able to copyright an AI-generated image because he wrote the code to produce the AI-generated image. So those are the two things being cited in this case, which is quite interesting.
What a weird body of case law. This is I'm not an IP attorney, as you can tell whenever we speak about these AI-related topics, but this is absolutely fascinating. I don't know where I come down on this. Yeah. At least I understand. I think we talked about this in the past where Getty won't even allow AI generated.
Yeah, they don't even want to deal with these questions.
They don't even want to touch it. Yeah, because these questions are so fascinating. Yeah. Is this piece of work, is it nothing more than just another copyrighted art piece? And I guess that it also goes into there's so many questions here. If the AI generated art, how much of it is truly AI generated? If it's how similar is it to the to a potential original?
Well, this has always been my question. If you and I were to both sit at the same Midjourney screen, and somebody prompted us to, come up with an image of mountains and with a stream and a helicopter flying through. What you and I would each feed into the machine to get to that would produce something different, right? So how much of that is us? How much of that? Yeah, it's really fascinating, right?
What I'd love to see is if we both get the same image. If for some reason we put in the exact same prompt,
right?
Everything for some reason is exactly the same. Who owns it at that point?
That is also an interesting question.
There's a lot of questions here. If you're an IP attorney, a professor, please feel free to shoot us a tweet, DM, or an email or whatever. We'd love to get somebody's take on this because this is not our purview. But it is fascinating to talk about.
It's fascinating and something we're going to keep talking about as this becomes more and more common, as we've seen over the last few months. But yeah, I would love to hear from people who know, have much deeper understandings of this arena and just the IP laws around it. That would be fascinating.
Oh, yeah, absolutely.
All right, well, let's transition then to some of the smaller stories for this week. The first one is a question that I actually would love to hear your take on as well.
Sure.
But Law.com is asking if pandemic-era lawyers, basically junior lawyers hired over the last 3 years, let's say, are undertrained because they just haven't been exposed to as many, as a much of a variety of cases as normal, and they haven't had the face time with kind of mentor lawyers in the office.
Oh, man, this is such a controversial question because it goes to the heart of remote work versus not remote work. So I will say this. I do think if you are a more senior attorney and you have actually taken the effort to train these attorneys, you can get it done. That training can still be just as effective as an in-person training, but you have to put in that work, right? You have to set up potentially weekly, even daily meetings through Zoom, Microsoft Teams, what have you. So if you are actually making a real effort there, I do think that those attorneys are probably well trained. If you're not, and you're kind of just letting them run wild, and you're not very great about, when I say run wild, I mean here are the cases, go for it. You see that with some shops. I don't condone that kind of training. I hate that kind of training, but I'm sure there's plenty of shops that do that. I'm sure there's been some impact. I definitely will say that I love remote hearings, for court. I loved those. It saved us a lot of time, money for the client. But there is something to be said for going to court, watching people argue motion after motion after motion. You pick up their arguing style. You see what works and what doesn't work. You see what arguments are being put. You see facial expressions, body language. Yes, you do get that through Zoom. I do think it maybe is a little bit more helpful in person. So I'd love to know from a junior attorney and a senior attorney if that's also been an impact. I tend to think maybe. I maybe think that if there was more of a mix of like going actually to court and seeing how attorneys argue. That would be helpful. But it's a very open question. It is certainly an open question on this topic.
To me, my worry, I don't work in the legal field, but even in writing and in journalism, there's kind of a lack of serendipity that occurs when you're not in the office, right? When you're in the office with somebody, something might just come up that you would have never expected, or you can't, schedule a Zoom call for. And it's a learning opportunity. It's a bonding opportunity. It's a whatever, right? That you gain experience, you gain exposure that way. So, yeah, I wonder if kind of more junior attorneys who over the last 3 years have not seen their partners as frequently, in the office, are missing out on that serendipity or just kind of that mentorship of just, building that bond over several years.
I think if you were a shop that was not great on mentorship, if you were just not potentially, we're lawyers, we could be, sometimes we're really good lawyers, but not good managers. If you're not a good manager, I imagine that during this pandemic, your management skills probably did not improve. And I would imagine had a more lasting effect on your junior and mid-level associates. So I do think that potentially is the case. If you're a good manager, I'm sure you got it done, but it maybe was a little bit harder.
Yeah.
But again, this is kind of like the IP question. If you are a junior attorney or a mid-level attorney, or even a senior attorney that manages junior attorneys, please feel free to write us. I'd love to know your take on this and your experience of managing or being managed and learning during the pandemic.
Or at least compare the two. Yeah. What was it like to manage, let's say, from 2015 through 19 versus 2020 through today, right? What is the difference? How does that look? Yeah.
Yeah. And I will say this, at least as a positive note, because things were done remotely, I got more hearing experience because I had the ability to do like a Miami hearing in the morning, and then I could do like a West Palm Beach. I was in South Florida, a West Palm Beach hearing in the afternoon. So there was plenty of positives there. It was so much easier too. I'd be like, get on there. So I could hit all of these hearings because if I had to do maybe something in Tampa, Florida, that's a drive. That's a real drive for me, and then that would really take the day. But now, when I was in the office, I could do Tampa, Jacksonville, Tallahassee, South Florida.
Has there been the same variety, the same diversity of casework, or has there been certain things that we haven't seen over the last 3 years as much? Maybe real estate, some type of thing?
No, I'd say like we've seen so many different weird events. Like you saw the rise and fall of like a lot of tech, for example. So you saw in like one genre of the industry, you saw lots of M&A, lots of deal work, lots of commercial work. And then you saw a lot of litigation. You saw some bankruptcy. You saw some down round related stuff. So it's definitely. I think you did see a good variety during that. I think in terms of like the actual cases, like or matters, it was the same. It's more of the like mentorship and the training.
Right. Interesting. All right, well, let's end then on something that we've touched about in the past, and you even said that this is probably what's coming, which is, if you'll recall, last month, the Third Circuit Court of Appeals invalidated Johnson & Johnson's attempt at the Texas two-step, which you had said at the time was going to portend that this might not be working so well in the future, that this strategy might be dead.
Yeah.
And here we are. The Justice Department is now requesting that the U.S. Bankruptcy Court for the Southern District of Indiana toss the Texas two-step strategy that 3M, which is another major firm, is trying to use in an earplug case that they're dealing with.
So this is such a common tactic in mass tort cases. This one are they're earplugs. That's right. And I do think we are seeing a trend, whether it's a public policy related trend, right? Because you're like, we cannot just continue to allow someone to basically take these liabilities, shove it on another company, file BK, and they're gone. Like it's not going to work, or something similar to that. It's not going to work anymore. So I do think this is the start of Johnson & Johnson was the start of the downfall of this tactic. Which again, I don't condone the tactic. I don't love the tactic. And when I say I love it, I don't like it. Period. So I definitely think you're going to see more, hey, let's at least take it, because you have to attempt it. Because I think corporates, like, you probably have a fiduciary duty to at least try to get rid of all of these liabilities. And I don't think it'll be successful for much longer.
Right. It seems like the precedence is now building up and saying you're 3M, you're Johnson & Johnson, you're some
That's
other
exactly
billion-dollar company. You can't pull this BK stuff anymore.
That's exactly right. And it was so common, especially in like asbestos litigation. You saw a lot of it. Talc, well, like Johnson & Johnson's a good example. And I'm sure it was in these other toxic chemical cases. Probably that's really common, like PFAS. I'm sure it was probably very prevalent in that kind of arena as well. So it's a trend. It's a trend in that direction, and I fully anticipate seeing more courts say, "I'm not doing this. No, not this time."
Yeah. Well, maybe that's a positive development then. Yet to be seen. Well, thank you as always for talking me through this. This was fascinating this week, so I really appreciate it.
Oh, my pleasure. And for all of you listening, if you have thoughts, comments, concerns, qualms, you just don't like my face, shoot us a message, shoot us a DM, shoot us an email. Let us know your thoughts.
Hey, I hope you enjoyed this episode. If you did, like and subscribe wherever you get your podcasts. Check us out also on LinkedIn and Twitter to keep up to speed with what we're doing. Catch you on the next one.